Court does call the case of the People versus Mario Floyd.
Good morning, Your Honor. Ashley Longing, Office for the People.
Good morning, Your Honor. Marcia Creighton on behalf of Mr. Floyd, who I believe is attending via Zoom.
State your name, please.
Mario Floyd.
Yeah. This is People's motion.
Yes, Your Honor. Thank you so much for setting this very quickly so that people could hear. I know the court has reviewed the motion. I'd like to start with a couple of housekeeping matters.
Yes.
I know Ms. Preacher got appointed this morning. So I had an extra paper copy of the police report that I gave her in court this morning, but I know that she hasn't had the benefit of reviewing a lot of the discovery in the case. So I just wanted to put that on the record. And mostly, Your Honor, we're here today asking the court to reconsider the bond. In my written motion, I did indicate that the defendant is charged with a variety of extremely serious offenses, including but not limited to armed robbery, carjacking, assault with intent to rob, all armed, larceny from a person, so on and so forth. My understanding is that the defendant is currently on juvenile probation related to a CHD. He has been not compliant with that probation, most recently being put back into detention in February and released back out to his mother in March. And in this case, he was in Ann Arbor after midnight with one other individual at the time of the armed robbery, but with a group of other individual times later than the armed robbery, a group of 4 juveniles and 1 adult, ultimately an entirety of 5 people. I do believe that the likelihood of conviction is extremely high in this case, as this armed robbery and carjacking was captured on video from the Bell Tower Hotel. Very concerned for the safety of the community, mostly a bit concerned about the defendant's ability to comply with court orders, given his probation and non-compliance there. People do recognize the defendant is extremely young and will turn 18 later this month. But we do believe that the PR with the home confinement tether is an abuse of discretion. We ask the court to revisit the issue of bond. Happy to answer any questions the court has. Thank you, Your Honor.
All right. So, Richard, I realized we were notified that you were.
Before we dive in, just a quick note. This commentary is created for educational purposes, designed to help those who may be confused or curious about courtroom processes. If you don't find it helpful, feel free to skip ahead. But for those who want a deeper understanding, stay tuned. It's about to get intense. What starts as a routine bond review is quickly turning into something much bigger. Prosecutors are arguing that this defendant, already accused of serious crimes, including armed robbery and carjacking, violated prior court supervision and now poses a major risk to the community. The defense is asking the court to trust a young defendant with family support, but the judge appears deeply skeptical. With allegations captured on video and questions about probation violations already on the table, this hearing may be heading toward a dramatic showdown over whether freedom before trial is even appropriate. Watch closely, because the judge's reaction is about to change the entire tone of this case.
Days from being released from that before he's back in police custody on these felonies.
Well, you reconcile it this way, Your Honor, because, it's a tough question to answer, but I want to do my best, okay? You reconcile it because he, in speaking to his mother and speaking to him, he understands the seriousness of this, and that's how you reconcile it. I mean, I get where the court's coming from, but this motion has to be, addressed. And, I appreciate the court listening to my arguments, but I think that there's other ways to ensure public safety. And that.
How do I not consider it an abuse of discretion where the co-defendant, as I'm to understand from the swear to, was standing between the victim in this case and the vehicle in a position that it's believed was going to stop the person from going to the vehicle, that this defendant actually pointed a pistol at the person, then struck the person with that handgun and took the phone. And this defendant did all of that. He has a PR the other defendant who was standing there equally is liable for what's going on. But that person gets $100,000 cash surety bond. None of this, I'll be honest with you, and again, I'll listen to you, but I'm telling you from where I'm starting, none of this makes any sense to me.
Well, I can appreciate the court's candor. The court's going to make their decision, and that's the court's prerogative to find an abuse of discretion. I mean, I don't have information as a swear to. I don't have the $100,000 bond that was set on the co-defendant. All I can say is that I believe it was Magistrate Odatello made that call, and he had the information. He had all of this information, I presume, because I haven't seen that video. I'm assuming, and maybe I'm incorrect in assuming, but he made that decision based on the information that they have. Now we're here, and if the court feels it's an abuse of discretion, it's within its power to do so. I'm saying that if the court is, just apply the standard that I rattled off earlier, my client has family support. My client, I've had a conversation with him. He understands that whatever court order said is followed. If he's able to post bond and release on bond, then that he has to follow his court orders. The family is suffering through financial hardship. In the home, it's a single mother home. There are 5 children, including my client, so there's 4 still at home, and she is the sole provider. So I'd ask the court to consider that when assessing bond, that, the family high bond would be financial hardship, and if possible, allow him to have a 10% privilege run. Thank you.
Ms. Feltus.
Because it is my burden, Your Honor, I just have a couple of more things I'd like to point out for the court. I want to make sure it's very clear. This firearm was a BB gun. It was a pneumatic gun, but it is incredibly realistic looking. I would ask if I've shown this to Ms. Cracher, if the court would consider looking at a photo of this to see how realistic this looks. I do think it's important when we talk about this to realize that. If there's no objection from defense.
No objection.
It's not labeled or anything, Your Honor, and I'm not admitting it, but I just want the court to see the firearm that was recovered. I would say the weapon. I didn't say firearm. I should say weapon. In my experience, this looks like a Glock, Your Honor. And honestly, it is amazing to me how realistic it is. With no orange chip, it's completely black, the dark gray black. And the last thing that I will just let the court know, I've already covered. I'll rest on everything I've already said. Thank you, Your Honor.
Anything else, Ms. Cracher?
Just what I already said before, especially about the financial hardship of any high bond will produce on the family, Your Honor. Thank you.
The court, upon receiving the people's motion, I've indicated, read the motion, reviewed the swear to. I also reviewed the arraignment so that I could fully understand what information the magistrate may have had at the time that the decision was made. I tried to give deference to the magistrate's decision regarding this. I will be quite frank with you, it is impossible for this court to do that in this case. The bond as set in this case, with all due respect to the magistrate, it's illogical to me. It makes no sense. I have someone, as I previously indicated, who is on or under sentence on a CSC 3, has not complied with the conditions of that probation. How would I even believe that that individual would comply with just conditions on bond on a capital case times 3? It doesn't make any sense to me. Further, that there is an indication, and I'm not sure why this was not taken into account. There is an indication that this might be a ring of individuals involved, some of them juveniles, and so that this not only is some isolated incident, but that this defendant may be involved in effectively a criminal enterprise that clearly would jeopardize and pose a risk to the community at large. I think it's, and it pains me to say this, that this bond virtually is illegal. Because, first of all, he's on bond and commits these offenses. Secondly, at the swear to, it was very clear that all of the elements necessary given this charge, all of the elements there regarding the presumption or of guilt or the likelihood of conviction were there, that quite frankly, I'm not sure why his bond was not denied. We don't, in a lot of cases, get to see that, or certainly not at the arraignment stage, wouldn't be able to make that finding that this likelihood of conviction is there. This one is very clear. He's caught on video. The specific question was asked by the magistrate regarding identification of these individuals, and the officer in charge was able to, or the officer swearing it out, was able to articulate specific things that pointed to this defendant and his cohort as the people that did this. I'm not making a finding of guilt, but I certainly on that low standard for the purposes of bond, I don't know how one gets past it, frankly. Was there something?
This is the moment the hearing takes a sharp turn. Notice that the judge is no longer focusing solely on the seriousness of the charges. He's focusing on trust and compliance. In bond decisions, courts often evaluate whether a defendant is likely to follow court orders and whether public safety could be at risk. Here, the judge is openly questioning how someone who allegedly failed prior supervision can be trusted under less restrictive conditions while facing far more serious allegations. That's a powerful signal about where the court's thinking is headed. What do you think? Should prior probation violations heavily influence bond decisions, or should every case be evaluated independently?
Be clear about that people did consider that he was a juvenile that was on juvenile supervision probation as opposed to an adult, just so that we're very clear that that wasn't going to be thought about. I did have time to do the research before getting it in.
I looked myself, and I don't know that I saw anything definitive. I mean, the cold-hearted reality is that it was, I mean, when one looks at the purpose of the rule, it's that the person is under court supervision and monitored, and then this happens.
Thank you, Your Honor.
And so, yeah, I think I have stated everything I have stated on the record. I also will indicate I am not, well, I don't judge a bond based upon other bonds that are set. There is a bizarre discrepancy between the two individuals involved in this offense. And clearly, based upon what is being said, this defendant was much more clearly involved with the activities of violence and harm toward the victim in this case. For those reasons, and having reviewed everything that I have, I regrettably but don't have any other option but to say that the setting of a personal recognizance bond in this matter, given these charges, given what I know about the case, and having reviewed everything, is a clear abuse of discretion. The court will vacate that bond and will reset the defendant's bond. I will leave the conditions that were set by the magistrate in place, but in terms of the monetary amount, I will reset the bond in an amount of $500,000 cash surety.
Before we consider 18%, Your Honor.
I will not, and mainly also because I don't know that the defendant being on probation violating this, my opinion is he's not entitled to it, and I'm certainly not going to exercise my discretion to grant.
Thank you, Your Honor, for considering that. Just had to ask. Thank you.
Thank you, Your Honor. I will also let the court know to schedule for probable cause conference 6 days.
Yes.
And discovery continues in this case and the investigation continues. And I do believe that we may have additional information by the time for the probable cause conference where the people may wish to revisit bond if our proofs become even stronger to request that bond be denied entirely. I do think that's a possibility in this case, but I don't know it for sure.
Understood. All right. Anything additional?
The people.
All right. Thank you.
Thank you.
The other, in my understanding of how this works, he sat on the 28th.
That is my
correct.
understanding, yes.
Yeah, that's correct.
And he is going to be transferred to our jail on the 29th.
Yes, correct.
So I don't know if you're aware of that, Ms. Craig.
I appreciate that, Your Honor.
All right. So, see everybody on the 28th. Then.
The counsel and I approached.
You may.
Thank you.
Mary Ken has the Simpson attorney for the people.
Thank you, Your Honor. Alex Warren Green on behalf of Mr. Larry. Mr. Larry, could you name for the judge?
Camera Larry.
Your Honor, for the record, people waiving a potential conflict with vulnerable support and also public defender believe such conflict exists. So we make this waiver in avoidance of all.
And Your Honor, for our part, we likewise do not believe any conflict exists. If a conflict were to arise, we would waive it.
All right. And the court, for its part, also does not believe conflict either in admission of court rules or the case is decided there under to the extent of conflict does exist. Given the waivers, the court will consent to hear this matter. All right.
Your Honor, it's the date and time for a bond hearing requested by the defense. Leading up to that, I had an opportunity to negotiate with the people. I believe we have reached a resolution. Mr. Larry has executed an advice of rights. I've provided the plea form along with the advice of rights signed by my client to the court.
All right. Court, the plea form indicates that the defendant would be pleading to added count 3 of aggravated domestic violence, the 1-year offense. Upon a successful plea to that charge, counts 1 and 2 would be dismissed. Defendant is also agreeing to attend Accountable Choices, a 52-week level 3 program, and rest on all counts, if any. There's also an agreement that the prosecutor will recommend sentencing under 7694A. That supports full understanding.
That was it.
And that's our full understanding. Thank you, Your Honor.
May I have him sworn?
You solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Sir.
State your name, please.
Camera Larry.
All right. Sir, it is this court's understanding that you are going to be pleading no contest to the charge of aggravated domestic violence. That is a misdemeanor punishable by up to 1 year incarceration or $1,000 fine plus court costs. Do you understand that?
I do not.
All right. Do you understand what a no contest plea is?
I do not.
All right, 2 things about it I have to make sure that you, and the first thing is that it means that you're not further desirous or wanting to contest this charge. You understand that?
I do not.
Second thing you need to understand is that for purposes of sentencing, the court will treat you as pled guilty. You understand that? You understand also that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court.
Sure.
All right. Basis, no contest plea.
Potential civil liability, Your Honor.
Sir, to the charge of aggravated domestic violence, how do you plead?
No contest.
Now, you understand that by pleading no contest, you will not have a trial of any kind. You signed an advice of rights form, is that correct? You have any questions regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of the trial. You understand that by pleading no contest, you're giving up those rights as well as other rights on there form. You understand you're giving up your right to appeal a right. Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today to get you to plead? Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily and of your own free will. Court has been provided and has reached Washington County Sheriff's Office report for their case number 2620178. Any objection from either party to the court having reviewed that report?
No, just,
None from the defense, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Sir, I do have to advise you that if between the time of my acceptance of your plea and your time of sentencing, if you commit misconduct as defined by the Michigan court rules, not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that? You do?
Sir.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
Court, no, Your Honor.
None from the defense.
And have I complied with the court rule?
You must satisfy.
Defense is satisfied.
Court will accept the defendant's plea of no contest to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14 probation. Sentencing will be June 15, 2026, 10 a.m. before Judge Washington. And maybe we can deal with motion to reconsider, but we can deal with the bond issue.
Thank you, Your Honor, and I very much appreciate the court accommodating this hearing. I think Mr. Larry's very appreciative of that as well, because when we were last before the court on May 19th, when Mr. Larry was remanded, the reason he was remanded was for the contents of the phone calls that were at that time revealed to the court and provided what the people believe to be an adequate basis for forfeiture by wrongdoing and potential witness tampering felony charges. I spoke to Mr. Larry about those issues that arise from it and how that not only would impact his case, but potentially the outcome of this entire proceeding and his potential of additional time in custody. Those things are not just a violation of the court's orders, but there's a reason we have those rules, and it is to protect the parties and the witnesses and really the integrity of the entire system. And, when I talked to Mr. Larry about that, I think he understands how serious it is. And we're before you today to ask this court to reconsider the determination that was made on May 19th. We're asking that the court considers reinstating home confinement. At the time that I initially asked the court to continue his bond, I know I talked heavily about the family support that Mr. Larry has. In the discussions I've had with him since then, I talked to Mr. Larry about, it's rare that I see that kind of family support among my clients. And, I have clients who maybe they start with that kind of family support, but as they appear more and more times before the court, it goes away. And I don't think he ever wants to be in that position. And, he doesn't want to burn those bridges. I think he's, if not before, come to appreciate that his parents are so involved because they care about him. In the time that Mr. Larry was out of custody between April 2nd and May 7th, he submitted 4 job applications while he was on home confinement. And I apprised the court that he, wanted to enroll in community college, but that's not exactly a remote goal. It's something he was scheduled for orientation on April 3rd, and subsequently violated the court's orders, got himself put into custody on April 2nd. So he's taken serious steps towards bettering himself. I think that the 52-week program that our agreement contemplates is something that will benefit Mr. Larry and make it so that he is not a person who comes back before this court. And hopefully this is the turning point in his life. You know, the agreement here is a considerable reduction. And Mr. Larry understands that. There are no felony charges anymore. But he has an opportunity to keep his criminal record clean at this point if he complies with the terms and conditions that are imposed on him by the sentencing court. I'm asking the court to consider allowing him to return to home confinement and establish a period of compliance prior to sentencing in the 14B district, so that at the time of sentencing, when the court's considering the people's sentencing recommendation to 4A, he has a period of compliance and he can present himself as a good candidate for probation. Your Honor, a couple changes to the motion that I would just like to put on the record. In paragraph 3, I said the bond was posted by Mr. Larry's parents. I should have written family members.
Yes.
In paragraph 21, I said, in addition to the orders I listed, a GPS hot zone tether, I conflated that with home confinement.
Okay.
But thank you, Your Honor.
Yeah.
Thank you, Your Honor. And Your Honor, first of all, people didn't respond via motion response. One, because this was a pretty quickly set, but more importantly, I didn't see anything additional in the motion, because the motion to reconsider. And our objection would be based on all the reasons that were put on the record when we were here Tuesday. Your Honor, I will say, as counsel indicated, this is a significant reduction of that moving forward with felony charges of witness tampering. It's not something that is commonly done when someone tries to interfere with the integrity of the criminal process. The reason we take these things seriously is because not only do we here have a victim of the assault that took place by Mr. Larry, we then have a victim to the whole court system and the procedure. The right to go through this process is a sacred right. And by no means, when we say accountability, do we mean that everybody has to be guilty or no contest prior to conviction. We do mean that they have to take accountability and follow the process. And unlike the victim of his assault, the court system is not so easily coerced or bullied. So that is all really important for Mr. Larry to know moving forward. The reason for the reduction in large part is because defense counsel, the court have taken this seriously. I have full faith with the counsel and the court that Mr. Larry will be properly informed about the consequences if he does choose to continue violating the rules, the laws, and the conditions that were put in place. With that, though, also comes great responsibility on his part to make sure that now that he's been given this chance, now that he has been fully informed of the consequences of his actions, he chooses to do the right thing. Based on his age and lack of criminal history, has been offered to me at this stage. It was done early enough before we dwell deeper into the witness tampering investigation. And it's really his opportunity to really change the outcome of his life moving forward. With all of that, Your Honor, I'm going to leave the court's discretion regarding the motion. The court is not only aware of this case and the factors that would play into it, but also very aware of the dynamics that go into these types of cases. The court also knows my position on these types of cases.
Larry? Your Honor.
Why do you think I was so angry with you?
I kept digging myself a bigger and bigger hole.
Is what?
I kept digging myself a bigger and bigger hole when I could have just.
Yeah, there's that. But you know, your family, I didn't know at the time, but they was your, like your siblings that posted this bond. And I'm looking at it and I'm thinking to myself, I didn't want, because you came initially before being in custody, I didn't want them to lose that. I felt you had enough family support out there that you could do the right thing. The problem was I didn't know everything that had happened. Young man, you were messing with fire in ways that, quite frankly, you don't even understand by doing what you did. When you find yourself in a position like this, it is no time to try to play around and think that somehow or another you're going to be able to do something that's going to manipulate the system. You hear me?
I understand, Your Honor.
And if you think I don't put up with it, I'm going to tell you right now, you're going before Judge Washington. She is not going to tolerate it, not one bit. So I'm going to suggest to you that you toe the line. I'll say also this, because sometimes it's said that a son can maybe pay for the sins of his father, but I'm not going to do that to you. Because what your dad did,
Yeah, high temper.
if I'd keep you locked up, no one ever goes out of this courtroom that way. And if he doesn't hear it somehow or another, you can let him know that. All right. And to let him know that I am at least somewhat forgiving. Okay.
Sure.
What I'm going to do is previous bond up to $10,000 that's already been posted. 10% that's already been posted. All the previous bond conditions, including the home confinement tether, is reinstated. Okay.
Your Honor.
You.
Your Honor.
Yes, I'm sorry before we leave. I remind you that it's obviously Mr. Larry is aware that he has to contact the victim, that also family members or friends are not to contact them.
You understand that, young man? And so I expect you to abide by that one. If nothing else, I hope you learn that from this. All right. You might want to just tell your father that too. Okay. Thank you. I'm fine. Loan services versus Randall Brady and Christopher Whitechat.
Good morning, Your Honor.
Go ahead, counsel.
Good morning, Your Honor. Anthony DeClerc on behalf of plaintiff P79103.
All right. Brady, Weinstedt, they are not present. If you'd like, did you pay for a second? There was no second mailing on this case. So I will have to, them not being here, I'll have to adjourn this matter out. Adjourn this out to May 29th, 2026 at 12 noon. That is a in-person hearing, counsel. That time. You can file a Zoom request if they're not appearing, but all right.
Thank you very much, Your Honor.
Thank you. Danbury Park Manor versus Miyoshia, I think, Bell. And I apologize if I said it.
Good morning, Your Honor. Greg Calabrese, P76393 on behalf of Danbury Park Manor. Your Honor, we were not able to accomplish service. We didn't get the summons back until Tuesday, so we're just asking for an adjournment.
All right. No service on May 29th, 2026 at 12 noon.
And we can just submit the Zoom request, Your Honor, to in the usual manner.
Yes, you can.
Thank you very much for your time, Your Honor. Appreciate it. Have a good weekend.
You too.
Thank you.
Elevate Property Solutions LLC versus Hamdia Syed Jama.
Morning,
Yeah.
Attorney. Oh, sorry.
Yusuf Jama. Go ahead, sir.
Good morning, Your Honor. Attorney Hamza Sob on behalf of the plaintiff.
Mr. Jama's here.
He tried actually. Apologize.
Dropped. He was here though. Okay, counsel, let me pass this briefly. It looks like defendant 2 was here but dropped. So we'll see if it comes back.
Okay. Thank you, Your Honor.
Thank you. Covington Apartments versus Jean Camano.
Good morning,
And
Constant for plaintiff.
Kima Camano. Do we have him?
Gentleman is here in the last block.
He was here in the last block. Is he? But he's not here now. We told him that he would.
Correct.
Counsel, if you'd like to take a default, I'm going to let you hit. The gentleman was here. We told him to wait. He's not present at this point. So if you'd like to take a default, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do, Your Honor.
All right, go ahead.
Your Honor, this is a termination of tenancy case, so there's no, we're not seeking any money damages, just a default judgment for possession only with a writ date of June 1st.
Judgment to the plaintiff. That is by default for possession. No redemption amount, writ to issue in 10 days.
Thank you, Your Honor. Have a great holiday.
You do the same.
Bye-bye.
Chittister Place Apartments versus Dorothy Walker.
Good morning, Your Honor. Paul Hughes, P31986, appearing on behalf of the plaintiff. I'm trying to get one.
Okay.
I'll try. Hang on.
Dorothy Walker. They are not present. You paid for the second hearing. There we go. We can see you. All right. And if you like to proceed, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do.
Go ahead, sir.
Plaintiff requests a default judgment. The amount of rent due is $1,092, court cost of $172, for a total amount due of $1,264. This is a possession only judgment, no money judgment at this time, with a writ to issue on 6/1 or after if the defendant does not pay or move.
Judgment to the plaintiff. That's by default for possession. Redemption amount is in the amount requested with a writ to issue in 10 days.
Thank you, Honor. Have a good day.
You do the same, sir. William Babbitt versus Douglas Swaffer and Patty Swaffer.
Good morning, Your Honor. William Babbitt.
Gotcha.
Do we have either checked in? We do not. I do not. I have to turn
I'm
it out.
here.
Okay, hold on. Where? Your Samsung. What's your name, ma'am?
I'm Patty Swaffer.
Okay. All right. Mr. Babbitt, what's your claim in this case? How much are you claiming is owed?
Your Honor, in this case, we're claiming back rent of $2,494.61. We have costs of $113.
This ruling delivers a massive shift in the case. After reviewing the evidence, prior supervision history, and the nature of the allegations, the judge determined that the original personal recognizance bond was a clear abuse of discretion and replaced it with a $500,000 cash bond. The court emphasized concerns about community safety, the likelihood of compliance, and the apparent strength of the prosecution's evidence. While this is not a finding of guilt, it demonstrates how seriously courts can treat risk factors when determining pretrial release conditions. Cases like this highlight the difficult balance between the presumption of innocence and the responsibility to protect the public while criminal proceedings move forward. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
I submitted a consent judgment the other day for a total of $2,607.61.
How much? I'm sorry, back up.
Sorry,
Your claim today.
2494.61.
All right.
Then 130.
Ma'am,
Yes,
how are you intending on getting this paid?
Doug and I are planning on doing, a payment plan. I just started a job a couple weeks ago and I also get my disability. So yes, we agreed that we would do, a payment plan so we can catch up.
Mr. Babbitt about that?
Yes, we did.
We did speak about it. They did consent to the judgment that I emailed over. Does the court have that?
I don't have that.
Okay, I emailed it to Ann the other day, but I can submit that.
I don't have a consent judgment at the file, but I wouldn't be able to enter a consent judgment at this point in time because she's going to need a week if she wishes to seek the advice of counsel. All right.
That's fine.
And as to defendant one, they're not present at this time. Did they sign off on this order consent?
Crawford?
Yeah, both.
That's
Okay, they both.
Doug and Patty were in my office the other day. There's Doug right there.
Yes, sir.
All right. I can enter this. Okay, I've got it. I can enter this next week, but I can't enter it today. You'll have an opportunity to speak with counsel on this case. I will adjourn this out to May 29th, 2026 at 12 noon. That's an in-person hearing, or you can submit Zoom forms to appear via Zoom.
Thank you, Judge.
Hold on. They're locked on me so that they're not jumping.
Yes.
And I just want to make sure they're on me.
Yes.
You're locked on me.
Yes.
Okay, go ahead.
We're all on then.
Huh?
We're all on then.
Yeah, is that it? That's how that works? You're right. I like the way you think. All right. All right. Court does call the case Prospect Realty Group versus Alexandra Bell Streety.
Good morning, Your Honor. Dana Hull on behalf of Prospect Realty Group.
Ms. Bell Streety?
Yes, I'm here. Sorry.
All right. Hold on one moment. Can we go off for a second? Did you want to bring her up this way? I'll take a brief break. We'll shut down. Hang on just 1 second. Let me do this one case and then I'll break. All right. All right. On the Bell Streety matter, what is plaintiff's claim?
Your Honor, this is a non-payment of rent case. I'm showing past due on of $3,450, cost of $175 for a total of $3,625. It's possession only.
All right, Ms. Bell Streety, how are you intending on getting that paid?
I should have a direct deposit of $1,000 today. I should have $1,000 by next Friday, and then the next week I get paid, and that would be at least $1,000 as well.
Okay, but then you're going to have June rent come in. So here's what I'm going to do. I'm going to adjourn this out to May 29th, 2026 at
3 p.m.
At 3 p.m. That's an in-person hearing. I suggest that I've written down what you're going to pay by that time. I'm going to suggest that you contact plaintiff's counsel's office, see if there's something that you can work out regarding a payment plan.
Okay.
All right. That hearing is an in-person hearing.
Okay.
Okay. Thank you.
All right.
Is that it for you?
It is, Your Honor. Thank you.
That is. All right, have a good weekend. And
Well, I'll see you
folks,
Saturday.